Hello, I am Dr. Rashmi A. Rajan, Associate Professor in Department of Commerce, Kumaraguru College of Liberal Arts and Science. Welcome to Unit 3, where we delve into the concept of winding up in company law. Winding up refers to the process of dissolving a company involving the cessation of business activities, liquidation of assets, and settlement of debts. In this unit, we will explore the different modes of winding up, including compulsory winding up by the court and voluntary winding up initiated by shareholders or creditors and court-supervised winding up. We will also examine the reasons that lead to winding up and discuss the legal and financial consequences for stakeholders. By understanding this process, you will gain insight into how company law ensures the orderly dissolution of companies when necessary. Meaning of winding up. Winding up is a formal process that leads to the dissolution of a company. It involves ceasing the business operations, liquidating assets, and settling debts with creditors. The goal of winding up is to ensure that the company's remaining assets are distributed fairly and legally among creditors and shareholders. Unlike simple cessation of business, winding up is governed by strict legal procedures to protect shareholders' rights. Through this process, the company is gradually dismantled and upon completion ceases to exist as a legal entity. Understanding the concept of winding up is crucial for comprehending the mechanisms that facilitate responsible corporate closure. Modes of winding up. There are three main modes of winding up: compulsory winding up, voluntary winding up, and winding up under court supervision. Compulsory winding up is initiated by a court order, typically when a company is unable to pay its debts. Voluntary winding up, on the other hand, is initiated by the company's shareholders or creditors without court intervention. The third mode, court-supervised winding up, involves the court overseeing the process to ensure compliance, though it is not the initiator. Each mode has unique procedures and requirements catering to different circumstances under which a company may need to be dissolved. Modes of winding up. Distinction among modes. To distinguish between the modes of winding up, it's essential to consider the initiators and oversight the involved. Compulsory winding up is initiated by a court, often due to legal or financial issues, while voluntary winding up is decided by shareholders or creditors when a company no longer wishes to operate. Court-supervised winding up combines voluntary initiation with judicial oversight, ensuring adherence to legal procedures. These distinctions highlight how each mode addresses different scenarios, providing flexibility in how a company may be dissolved depending on its financial conditions and stakeholders' needs. Compulsory winding up by the court. Compulsory winding up occurs when a court orders the dissolution of a company, typically due to serious concerns such as insolvency, illegal activities, or actions against public interest. This process is initiated by a creditor, shareholder, or regulatory body who petitions the court. Common reasons include the company's inability to pay debts, unresolved disputes among management, or fraudulent activities. The court's involvement ensures that the winding up process is conducted legally, protecting the rights of creditors and preventing harm to the public. Compulsory winding up by the court process overview. The steps in court-ordered winding up. In compulsory winding up, the court follows a structured process to ensure fairness. After reviewing a petition, the court assesses the grounds for winding up and, if justified, issues a winding up order. A liquidator is appointed to oversee asset liquidation and debt settlement. Under court supervision, notices are sent to creditors and stakeholders to inform them of the proceedings. The liquidator's role involves collecting assets, settling liabilities, and distributing any remaining funds to shareholders. Finally, once all the debts are cleared, the company's name is removed from the registry, marking its legal dissolution. This process emphasizes transparency and protection of stakeholder interest. Voluntary winding up. Voluntary winding up is initiated by the company's shareholders or creditors without court intervention. This approach is often preferred when a company decides to close operations but maintains sufficient assets to meet its obligations. The voluntary winding up process is generally faster and less costly than court-ordered procedures. By choosing this route, stakeholders can control the winding up timeline, ensuring a smoother and more efficient dissolution. Voluntary winding up reflects a proactive approach by companies to close operations responsibly, preserving the remaining value of stakeholders. Types of voluntary winding up. Winding up is applicable to solvent companies where members or shareholders decide to close the company. This decision is taken when the company can meet all its liabilities. The process begins with a declaration of solvency, confirming that the company can settle its debts within a specified period, usually 12 months. This type of winding up allows shareholders to realize their investments, ensuring an organized closure. Members' voluntary winding up is a strategic choice for companies that wish to dissolve while maintaining the financial responsibility to creditors and shareholders alike. Types of voluntary winding up. Creditors' voluntary winding up for insolvent companies. When a company is insolvent, it may opt for a creditor's voluntary winding up, whereas creditors play a crucial role. Since the company cannot pay its debts, creditors have a say in appointing a liquidator to oversee the asset liquidation. This process ensures that creditors' interests are prioritized in the distribution of any remaining assets. Creditors' voluntary winding up provides a structured means for insolvent companies to close while fulfilling their obligations to creditors as far as possible. It emphasizes cooperation between the company and creditors, aiming for a fair resolution of outstanding liabilities. Winding up subject to supervision of the court. Supervised winding up is a hybrid approach where the court oversees the winding up process, even though it was initiated voluntarily by the company. This form of winding up combines the benefits of voluntary closure with judicial oversight to ensure compliance with legal standards. The court monitors the liquidator's action, especially if there are complexities in asset distribution or creditor claims. Supervised winding up provides a layer of protection for stakeholders, ensuring that the process remains fair and transparent and meets all legal requirements. Winding up subject to supervision of the court. Ensuring the process compliance and stakeholder protection in supervised winding up, the court plays an important role in ensuring the winding up process is conducted according to legal standards. This includes overseeing the liquidator's action, reviewing the creditor claims, and resolving disputes that may arise during the proceedings. The court supervision helps protect the interest of creditors, employees, and other stakeholders, ensuring that the process remains transparent and orderly. Through its oversight, the court safeguards the winding processes, maintaining trust in the company's final dealings and fair treatment of all parties involved. Consequences of winding up. Asset distribution, liquidation and debt settlement. A key consequence of winding up is the distribution of assets, which involves liquidating the company's holding to settle outstanding debts. The liquidator converts assets into cash and distributes them in a defined order of priority, first to creditors and then to shareholders. This liquidation process aims to satisfy the company's liabilities as fully as possible. Asset distribution reflects the company's commitment to fulfilling its obligation, allowing creditors and shareholders to recover their investment to the extent available. This orderly asset allocation is crucial for maintaining fairness during the company's dissolution. Consequences of winding up. During winding up, a company ceases all business operations and its management powers are effectively frozen. Directors no longer have authority to make decisions on behalf of the company, as control shifts to the appointed liquidator. The company's focus becomes solely on asset liquidation and debt resolution, marking an end to its commercial activities. This cessation signifies the conclusion of the company's operational existence, underscoring the legal finality that winding up brings. It is a structured transition from active operation to dissolution, ensuring clarity for all stakeholders. Consequences of winding up. Winding up carries effective legal and financial implication for all parties involved. Creditors may face partial or full loss of repayment depending on available assets. Employees may lose their positions, although they may receive priority in asset distribution if wages are outstanding. Shareholders, in turn, may only receive remaining assets after all debts are settled. These legal and financial impacts highlight the importance of fair and transparent winding up procedures, ensuring that each party receives due consideration. By acknowledging all these consequences, winding up safeguards stakeholders' rights within the limits of the company's final resources. Summary: key points on winding up, modes, court involvement and consequences. In summary, we have explored the concept of winding up, covering its different modes: compulsory, voluntary and court supervised. We examined the reasons for compulsory winding up by the court and the advantages of voluntary winding up for solvent and insolvent companies. We also discussed the consequences from asset distribution to the cessation of business activities and the legal and the financial impacts on stakeholders. Understanding these aspects of winding up is essential for managing corporate closure responsibly, safeguarding the interests of creditors, shareholders and employees. Now that we have covered the essential aspects of winding up, including its definitions, various modes, court involvement and consequences, it's time to test your understanding with an assessment. This assessment includes 10 multiple choice questions designed to reinforce the core concepts from Unit 3, such as the types of winding up, compulsory, voluntary and supervised, the reasons for court-ordered winding up, asset distribution and impact on stakeholders. Each question presents 4 options, allowing you to select the answer that best reflects your understanding. Take a moment to consider each option carefully, as this is an excellent way to confirm your grasp of the critical elements of winding up in corporate law. Thank you.